Okay, good afternoon, everybody. I'll warn you at the beginning that this is a fairly compressed version of a relatively lengthy paper, but if there is any more detail that you want on this, I'll give you the reference to the full version of the paper at the end of the presentation. So just to bear that in mind, if there's points at which you're thinking, can you please say more, because it's just not going to be possible in the time available. What I want to speak about is the question of whether or not Irish child law can be reconciled with our obligations under the European Convention on Human Rights and Article 8 of the Convention in particular, and to assess the question of whether or not, in the context specifically of parents of children who are not married, so unmarried fathers or also social parents within same-sex couples or other types of living arrangements, and your non-traditional, non-marital families, how does the question of how Irish law allows, or in some instances doesn't allow, the family links between those children and their parents, be it unmarried fathers or social parents, how does that line up with the jurisprudence of the European Court of Human Rights in terms of what it said about the scope of Article 8 and what Article 8 requires? And there's a perception sometimes when you look at the definition of family life, which is provided by Article 8 of the European Convention, and when you contrast it to Article 41 of the Irish Constitution, it's tempting to jump to the conclusion that Irish law clearly falls short of Article 8 obligations. But the question is a little bit more complicated than that, and I just want to talk through that and to tease out what exactly does Article 8 require, and also to question what is it likely to require in the future, because of course Strasbourg jurisprudence is developing all the time, and there are issues on which at present there's no European consensus, but on which consensus is likely to develop in the future and obligations may change. But to briefly recap on something many of you will know, which is that Article 8 of the European Convention on Human Rights protects, broadly speaking, the concept of family life. And now this can be brought into existence either through form, in the sense of a marriage ceremony, or also it can be brought into existence through the function of a family being fulfilled and through the intention of the parties to live as a family being demonstrated to the court. And so a well-established concept of the Strasbourg jurisprudence is the idea of the de facto family, or de facto family ties, de facto family life. And I'll explain in a moment how this can give rise to both negative and positive obligations on the behalf of the state. Now, when you contrast that to Article 41 of the Constitution, it's a much narrower concept of the family. It protects only the marital family. There's a duty on the state to guard with special care the institution of marriage and the marital family, which is given inalienable and imprescriptible rights. And it's a very much all or nothing approach, that either you're a married family or you're not a family at all for the purposes of Article 41 of the Irish Constitution. Now that presents a pretty stark contrast, and when you look at some of the classic Strasbourg case law in this area, cases like Marx versus Belgium, for example, which state that it's not permissible for the state to privilege the marital family in a way that seriously disadvantages other types of family units. Again, as I said, it's tempting to jump to the conclusion that this leaves Irish law far short of fulfilling our Strasbourg obligations. But there's a little bit more to it than that. So looking at the definition of family life under Article 8 of the European Convention, it's far broader than the very narrow Irish constitutional concept of just the family based on marriage. It obviously includes the connection between the two parties to a marriage, between married parents and their children, between unmarried mothers and their children, between siblings, grandparents and grandchildren. Unmarried fathers are found to enjoy family life with their children where it can be shown either that clear ties already exist between them, or where the father clearly demonstrates his intention to establish such family ties through going through various legal proceedings. And so in many cases the court will accept that family life between a child and an unmarried father does exist for the purposes of Article 8. Social parents, so where you have somebody who is fulfilling a parenting role but is not a biological parent, may also have their family ties to a child recognised, and you also have the family ties between two members of an unmarried couple who don't have children, and you have same-sex couples. The court has recognised that to date, in terms of the case law, that the two parties to a same-sex couple do enjoy family life within the meaning of Article 8. It has not yet recognised specifically the idea of family life between a same-sex couple and a child, because the couple in that case did not have a child, but lining that up with the earlier cases on social parents, it seems clear that would fall within the definition of family life under Article 8. So this is a very expansive definition, and when you talk about children who are growing up in less traditional types of family units, you see that clearly they will be likely to fall within the scope of Article 8 of the European Convention of Rights, but finding themselves falling outside of the scope of Article 41 of the Irish Constitution. Now, if you do fall within the scope of Article 8 of the European Convention of Human Rights, this gives rise to both negative and positive obligations on the part of the state. A negative obligation to not interfere with that family life, save in circumstances permitted by Article 8, paragraph 2. But what I want to focus on more particularly for this particular talk is to look at the idea of the positive obligation on the state to provide legal recognition of the family ties which may exist between children and unmarried fathers, or children and their social parents in same-sex couples or other non-traditional families. Now, what the court has said about this issue is that where a positive obligation arises, the obligation is that the state must provide a mechanism which allows for children to be legally incorporated into that family unit. And in some cases, some of which involve Ireland, for example Johnston versus Ireland, where there is an absence of a legal mechanism which allows the incorporation of a child into the de facto family unit in which the child lives, that may be found to constitute a breach of the state's obligations under Article 8 of the ECHR. Now, the case law gets a little bit murky when you get into the question of positive obligations, because we do have some cases where the court has recognised that family life exists within the meaning of Article 8, giving rise to negative obligations, but has found that perhaps no positive obligation directly flows from the recognition of family life existing. So you might find that in certain circumstances the court basically accepts that a family does exist, but that the state has no obligation to actually recognise that family, even though the Strasbourg Court has recognised it as a family. X, Y and Z versus the UK and Schalk and Kopf versus Austria are two examples of this, where what the court has basically said is that yes, we accept that you are a family with Article 8 rights, but because of a lack of European consensus on this issue, it remains within the margin of appreciation of individual states, at least for now, and that they're not yet obliged to provide legal recognition of that family unit and of those family ties. But in these cases, where these cases are predicated on European consensus and where trends are clearly moving in that direction, over time it is likely that in the case of, for example, Schalk and Kopf, which concerned a same-sex couple where no positive obligation was found to exist, as more and more European states provide laws which provide legal recognition of family ties between same-sex couples and children, it's likely that a point will be reached at which the court says there is now a majority of states within Europe who provide this recognition, and therefore the margin of appreciation is eliminated and the positive obligation does arise. But for now, in certain categories of cases, we don't see the positive obligation. It has been recognised with respect to unmarried fathers and children and that particular connection. It has not been recognised with respect to social parents or same-sex couples and their children as of yet. Now, coming back to the question of the Irish Constitution, clearly Article 41 is on a completely different planet to Article 8 of the ECHR in that sense, but that doesn't necessarily mean that Irish law is in breach of Strasbourg obligations, because of course you can do an awful lot at a legislative level. And if you look at the examples of the case law concerning unmarried fathers which have gone to Strasbourg from Ireland, in particular Johnston, which I already mentioned, and also Keegan versus Ireland, we saw in those cases that Ireland was found in breach of Article 8 obligations because of the provisions of Irish law regarding unmarried fathers and their children. But in each instance, the relevant reforms which took place after those cases took place at a legislative level. And so there's a lot you can do in terms of recognising links between children and their parents at a legislative level that doesn't necessarily have to be dealt with on a constitutional level. One perception which is out there quite commonly is that Article 41 actually precludes that type of legislation, and certainly that it precludes legislation which would treat extramarital families equally or the same as families based on marriage, and that often acts as a barrier to legal reform in this area. But actually a careful reading of the constitutional case law on this issue, if you look at cases like Murphy versus Attorney General, like OB versus Orr and other similar cases, in fact what the Irish case law has said on this issue is that Article 41 does not allow for extramarital families to be treated more favourably than the marital family. Article 41 permits more favourable treatment for the marital family, but Article 41 does not require more favourable treatment for for the marital family. So there's a distinction to be drawn there. It's one thing to say you can't treat them better, and you can treat them more. You can treat marital families more favourably if you wish, but it's another thing altogether to say that Article 41 completely precludes any legislation which equalises the position of the extramarital family with the marital family. And we have lots of legislation which does just that. I've just given one example there of the social welfare, where payments for cohabiting parents who are not married are identical to cohabiting parents who are married. And it would be completely unworkable to have an absolute blanket ban on equal treatment in legislation for all extramarital families as compared to marital families. And so in that sense, it would be perfectly possible to enact legislation which treats the connection between children and unmarried fathers, or children and social parents, on an entirely equal basis to the connection between children and marital parents. And that would not be precluded by Article 41 of the Constitution, and it would certainly measure up to the requirements and even future potential requirements of Article 8 of the ECHR. Our current legislation on this issue, what we have in the Guardianship of Infants Act 1964, which many of you will be familiar with, is that automatic guardianship is only granted either to married parents or unmarried mothers. So in terms of children of parents who are not married, the connection between the child and the mother is automatic. The connection between the child and the father will not be automatically recognised. The father may be appointed a guardian either by consent of the mother by statutory declaration or an application to the court, but it's not automatic. Social parents are basically excluded. I'll come back later on, but so in terms of the concept of guardianship, there's the only real possibility for social parents to be appointed a guardian at present is where the biological parent of the child dies, and the social parent is appointed in a will or by the court at that point. But of course, when you talk about the recognition of family ties between children and their parents, you have other relevant provisions. You have the welfare principle, and the United Nations Convention on the Rights of the Child clearly emphasises the importance of legal recognition and maintenance of relationships between children and both parents. We have specific statutory provision which obliges courts to have regard to whether the child's best interests are served by maintaining the relationship and regular contact with both the mother and the father. So that clearly is of use to unmarried fathers in cases like this, although perhaps not so much to the social parent, again, who's not specifically mentioned in the legislation. But I'm going to see when we get to the case law in a moment that the case law has addressed that point as well. Now, to look at the case law in the Irish courts on this whole question of the de facto family, the courts have always said that Article 41 of the Constitution only recognises the marital family. It does not recognise the de facto family, and sometimes there's an assumption which grows out of that case law that because the courts have said that Article 41 doesn't recognise the de facto family, that therefore all of Irish law provides no recognition for the de facto family. But that's not a correct reading of the case law, even though it's a commonly held perception. The two major cases on this issue from the 1990s, JK and WOR, in both cases the court said absolutely Article 41 only recognises the marital family and not the broader de facto family. But in both cases, the Supreme Court also said that where a child is born into a de facto family and where the father, and they both concerned unmarried fathers, just by way of context, where the father plays an active role in raising the child, well then that existence of that de facto family unit and those de facto family ties are a factor which the court is obliged to take into account when applying legislative provisions on guardianship, custody and access. And so you see there's a big difference between saying Irish law provides no recognition of the de facto family at all and saying that a court is obliged to take de facto family ties into account when applying guardianship legislation. And given that these cases happen in the district court with very little discussion of the Constitution going on really, that actually narrows the gap quite significantly between Irish law and what is required under the Article 8 of the European Convention on Human Rights. Now, what we've seen in more recent years is that from this starting point of two Supreme Court cases saying that de facto family ties between children and parents are a relevant factor when applying guardianship and custody legislation, we've seen more recently a couple of cases in which the Irish High Court tried to push the boat out a little bit on this and provide some additional recognition to the concept of the de facto family in Irish law. The first one I want to mention is GT versus KO from 2007. This was an international child abduction case where you had a father who was not a guardian of his child but played an extremely active role in every aspect of his children's life. The relationship broke down and the mother took the children to England, and the father sought to have them returned to Ireland under the International Child Abduction Framework. Now, in line with previous case law under the Hague Convention, and we have here a sort of a two-track framework, because you have the Hague Convention, you also have the Brussels II regulation. In line with previous case law on the Hague Convention, it was held by the court that because the father was not a guardian, because the father had no constitutional rights under Article 41, that he therefore did not have rights of custody within the meaning of the Hague Convention. Now, there's a separate element of the decision about rights of custody in the district court, which I won't get bogged down in. But just to note that for the purposes of the Hague Convention, this father was found to have no rights of custody, in spite of the clear connection between the father and those children in that case. And you can see that Justice McKechnie in the High Court obviously thought this was ridiculous. He said as much, more or less, in his judgment. And so he went around this very circuitous route of looking then at the Brussels II regulation and said, well, because the Brussels II regulation is an element of EU law, because of Article 29, that's not bound by our constitution, it actually takes precedence in a case of conflict, and because Brussels II falls to be interpreted in light of the ECHR, the judge said, well, going this way around it and trying to circumvent Article 41, we can actually see that where clearly de facto family life exists between this father and this child, that this father does have rights of custody under the Brussels II regulation, even if not under the Hague Convention. And so that it's a very narrow concept of rights of custody, of course, in the context of international child abduction law. But we saw the High Court there engaging in a fairly convoluted and indeed unnecessary set of reasoning, in the sense that because the father had made an application for guardianship in the case, rights of custody vested in the district court at that point, and the children had to be returned anyway. So Justice McKechnie didn't need to go there in his judgment at all. But he did nonetheless, because he obviously felt that the idea that the law would provide no recognition of a father who got his children up in the morning, took them to school, took them to the doctor, fed them, dressed them, everything else, he obviously felt this was ridiculous and wanted to provide some recognition of that connection. And so he did it in this very circuitous way, using Brussels II in conjunction with Article 8 of the ECHR. The following year then, we saw the High Court go another step again in MacD versus L. This was a case involving a lesbian couple who had had a child by way of sperm donation. The donor sought access to the child, and the case came to the High Court for resolution. The High Court, on the evidence, decided that because the child was being brought up in a loving and stable environment by the two women, that the disruption that would be introduced into the child's life by bringing the donor into the fray, especially where he had a very tense relationship with the two women who were raising the child, that this disruption was not in the best interest of the child. Now, that decision could have been, in a sense, stopped there, because the Guardianship of Infants Act says that the welfare of the child is the primary consideration, and the welfare principle, in a sense, would justify that decision in of itself. But the parties had also made arguments based on Article 8 of the ECHR, and so in refusing access to the sperm donor in this case, Justice Hedigan in the High Court also decided to support his decision by making reference to the fact that the couple and the child were clearly a de facto family within the meaning of Article 8, that they had Article 8 rights, and he used that as further support for his decision in saying that he would not grant access to the child to the sperm donor and disrupt that de facto family unit any further. Now, that decision was appealed to the Supreme Court, and we see from the earlier cases we saw in the 1990s, JK and WOR, you saw the courts recognising this concept of the de facto family for the purposes of legislation, if not the Constitution. We saw the High Court in two further cases trying to add to this a little bit, but in 2009 the MacD case was appealed to the Supreme Court, who clearly weren't very enamoured with this direction of case law, and unanimously overturned Justice Hedigan's judgment, and in doing so made some fairly strident statements about this idea of the de facto family in Irish law, and actually took the concept back took it back even further beyond what the Supreme Court had held in the 1990s. It didn't really reference or engage with those cases very well, but it wasn't as simple as the court simply stopping the line of development which had happened in 2007 and 2008. It actually set the clock back to pre-1990 in a sense. The court held that there was no such concept as the de facto family in Irish law at all. So not just in the context of the Constitution, but said it was a concept unknown to Irish law. You can see in the judgment there was quite a bit of scepticism on the part of the judges in terms of the use of the ECHR. Justice Hedigan had made reference to a constitutional silence on the issues before the court and the High Court. And looking at that, the Supreme Court said, well, if you're using a constitutional silence as your justification for relying on Article 8, well, you're not falling within the framework of the European Convention on Human Rights Act. The European Convention on Human Rights Act only allows you to rely on Strasbourg case law when you're interpreting or applying domestic legislation, so a constitutional silence is no good to you. Now, I would argue that the Supreme Court got that point completely wrong, because Justice Hedigan, in referring to the constitutional silence, was only really making the point that the Constitution didn't preclude him from doing what he was doing. There was no barrier in the Constitution to utilising Article 8 in this way. There was no conflict. And was he interpreting and applying legislation? Well, of course he was. It's a custody and access dispute, and every custody and access dispute by definition involves a court applying sections 3, 11 and 11D of the Guardianship of Infants Act 1964. And so if he's interpreting and applying legislation, well, then he is obliged by the European Convention on Human Rights Act to do so in a manner, so far as possible, that is compatible with Ireland's convention obligations. So that's one element of that Supreme Court decision which I felt they got very wrong. And so it seemed on its face like a very stark decision which set back this idea of recognising de facto family ties in Irish law, and which would seem to give rise to all sorts of potential difficulties in terms of our compliance with our obligations under the Convention. But having done all that, the court then turned around and said, but of course we have to have regard to the child's environment, where the child has grown up and the relationships the child has, and all of the members of the court agreed that the relationship between the child and the non-biological parent in this case was a factor which must be taken into account by the court when applying legislation in a custody or access dispute like this. And so if this is a factor which must be taken into account, well, then the court is in fact actually providing some recognition of these de facto family links, in spite of the fact that it's just said it's not going to. It really is doing it. So you'd wonder why the court felt the need to make such a song and a dance out of rejecting the concept of the de facto family in the first place, because actually it is indirectly recognising it anyway. So to summarise, in terms of can we reconcile these elements of Irish child law regarding the question of unmarried fathers and children, regarding the question of social parents and children, can we reconcile Irish law with Article 8 obligations on these points? In many cases we can. For now, the question is what will happen as the positive obligations become developed in future case law. So Article 8 gives rise to a positive obligation to recognise ties between children and unmarried fathers. Because of having been found twice in breach of our Strasbourg obligations in Johnson and Keegan, our legislation now allows for this. As of yet, there's no positive obligation to recognise ties to social parents. It's likely that such a positive obligation will be recognised in future case law, but for now, the positive obligation doesn't arise. As I mentioned, our current legislation doesn't provide such a mechanism in terms of allowing for a social parent to be appointed as a guardian unless the biological parent dies. And if in the event that the biological parent is still alive and the relationship breaks down and there's a custody dispute, well, essentially a social parent has no chance in that custody dispute. They can apply for access, but regardless of what might be in the best interest of the child, there's no mechanism for a social parent to be granted custody at present. And so that is a potential point of contention in terms of whether or not Irish law will remain in line with any future developments in the case law. But for now, there doesn't appear to be a breach in this respect until those positive obligations are recognised. But having said all of that, we see the Irish courts holding that relationships between children and social parents are a factor that must be taken into account by courts when they're determining access disputes. So at least in the context of an access dispute, that does appear to provide some recognition. Whether or not that would be enough to fall into line with any future positive obligations remains to be seen. The absence of the possibility of custody coming under that umbrella as well potentially would be a sticking point in that regard. So everything I've said here is fleshed out in a lot more detail. It's just been published in the International Journal of Law Policy and the Family. So if you have access to that in Oxford Journals online, you can download it, or if you don't, if you feel free to send an email to myself, I'd be happy to send it to you, as long as you don't tell Oxford University Press that I'm breaching their licence. So thank you very much.